Good afternoon to everyone. We're about to start the breakout session on legal education. My name is Ayi Ekpenyong Edet Ima. I'm the coordinator of this session, and on behalf of the president of the Nigerian Bar Association, Mr. Olumide Akpata, and the chairman of the technical committee on conference planning, Mr. Tobena Erojikwe, I want to specially welcome you to this session on legal education. As we all know, the legal education system is declining rapidly, and there is this consensus that there is a need to urgently reform the legal education system in Nigeria in order to make it very suitable for the 21st century lawyer. And to discuss the issues in the legal education system in Nigeria, we have a lineup of speakers, carefully selected. They are made up of both practitioners and academics. Please join me as I welcome the moderator of today's session to the stage, Professor Ernest Ojukwu, Senior Advocate of Nigeria. In no particular order, may I also welcome Professor Yu Chukwuma Eze, Senior Advocate of Nigeria. Professor Chukwuma Eze is the acting Vice Chancellor of Imo State University. Prof, you are welcome. We are happy to have you in Lagos. It gives me great pleasure to welcome to join the panel a man I respect so much, a man who has taught so many lawyers. Please join me and welcome Professor Olanrewaju Fagbohun, Senior Advocate of Nigeria. Prof is a professor of environmental law at Lagos State University. He's the former Vice Chancellor of Lagos State University. Prof, thank you. Thank you for joining us. Please, may I also welcome to join the panel Dr. Nwachukwu Igu. She's a senior law lecturer at Nnamdi Azikiwe University. Thank you, Doctor. Thank you so much for accepting to join this panel, regardless of the short notice. May I also welcome Victoria Oloni to join the panel. Victoria is a solicitor with Detailed Commercial Solicitors. Thank you so much. Our moderator, over to you, sir.
All right, thank you very much, colleagues. Good afternoon. Our session is the Fit for Purpose Lawyer, Reflections on the State of Legal Education in Nigeria. And our panel is made up of a very strong, experienced team of lawyers who are coming from different angles of the profession. We will have Professor Yu Chukwuma Eze, who started as an assistant lecturer in his teaching career. And so he has learned, he has understood the system from toddler as a teacher to present when now he's a VC. He was also a dean of the Faculty of Law. And he was also a dean of the School of Postgraduate Studies of the University, Imo State University. So, and from his assistant lecturer position, he has been in very active legal practice, except for now. I don't know whether you are still going to court. But before the VC position, I know he's been in active legal practice. In fact, when he was an assistant lecturer, he was always following his in that case. Professor Olanrewaju, I call him Larry Fabo, SN. Of course, Yu Chukwuma is also SN. And the biggest portfolio I have is that Yu Chukwuma was my student, and I employed him as assistant lecturer. And he was the first person to harass me because I wasn't interested in being a son. I wasn't planning to do anything with it. He would take off from Owerri and come and harass me. I should apply. I will promise him I won't apply. Until I was sacked as DDG, Law School. He appeared the next day. That thing I was telling you now, apply. You must apply now. You must give me an undertaking to apply now. I promised him I apply, and I applied, and I got it. So after I applied, I also told him, you must apply now too. A couple of them, even his successor, Erugo, Samuel Erugo, I said, you must apply now too. All the chaps I employed as assistant lecturer, I've been harassing all of them. You must apply with me. So I'm happy to put him on my CV as one of my, and many of them are here. All troublemakers, all big guys in their places. Very many of them are here. I'm always very proud to be associated with having them around me. Of course, Larry SN is another towering inferno, also from toddler in the system. He became also Dean of Law and Vice Chancellor, Lagos State University, and SN. And he's also being in active legal practice. I always say there's a difference between those who like to just copy and paste articles from academic point of view because they want promotion, and those who write from experience. If you look at their articles, these guys I'm telling you, you know that they write from the heart. The articles they are writing, they write angrily, anger. And you can't write angrily unless you are dealing with experience, something that is disturbing you, and you apply the things you have learned from the field into it. And that's how he has grown. He's an angry professor. Of course, we have our darlings here. Dr. Nwamaka Igu is also learning the ropes very fast. I met her a couple of years ago in circumstances that were not too good in the family, but I'm so happy that she has broken out from that dark cloud of that time and is standing on her own as an academic, strong with a PhD. A senior lecturer now at the Faculty of Law, Nnamdi Azikiwe University. She will also talk from that perspective of her experience. We have our youngest darling here, Victoria Oloni, who is a solicitor at Detail Commercial Solicitors law firm. How many years at bar now? 1 year at the bar, yeah. She's the oldest panel member here. Her own experience will likely be more apt than ours because she's coming right from the field as the product of the system that we are all complaining about or thinking about changing. So I'm going to start the panel work by just inviting a few presentations from the speakers, not more than 10 minutes each, because I want us to also be like a discussion thing. Can colleagues who are at the back can move ahead, come forward and join us? One of the things I learned because I was a backbencher is that anytime you come to a program and stay at the back, you get used to it. Sooner or later, you'll be at the back at many times. If you go to church, you'll be at the back. God won't see you. If you go to anywhere you go, by the time they will you are trying to travel, they have too many people in the flight. It's the people at the back, they will say, please, let's push your own travel to tomorrow. So move back so that God can see you front. Please, move forward, move forward. Don't allow yourself to be at the back. It's not a good thing. I'm going to ask you, Chukwumeze, to talk to us a bit about what the universities are doing in relation to our legal education. Remember, our colleagues, remember that the topic of our presentation is the fit for purpose lawyer, reflections on the state of legal education in Nigeria. Prof, you.
Thank you, sir. Thank you, my teacher, my employer, and my mentor. my senior colleague in the university system, at least as vice chancellor. I will come to you to drill me on how you were able to get money from state government. I appreciate our two lady colleagues, especially my colleague from Oka and my PhD student one time. I thank my classmates here. I thank members of Were branch that came here because of me. And my lovely wife, sir. My package, too. Because I taught her in the university. So in my CV, she's number one, my one baggage. Thank you very much. My assignment is to spend the next 10 minutes talking about what the universities are doing. Fit for purpose lawyer, simply put, a lawyer who is a round peg in a round hole. Somebody called to the bar, somebody who satisfies and desires of his clients. Somebody whom we are all proud of. Somebody whom the legal profession is proud of. Somebody whom your university is proud of. And somebody whom the client will be proud of. That's a fit for purpose lawyer for that purpose. The general belief in this country now is that the level of legal education is moving downhill at a very high moment. What are the universities doing regarding that? The truth is that some of the problems are problems of system. Nigeria generally is moving downhill. You don't expect the legal profession to soar ahead of above Nigeria. So every profession, the medical profession, I have somebody here who traveled to the United States, my classmate here present, to treat himself. He will tell you what he has spent in Nigeria trying to treat himself, not even single diagnosis. So the problem is not exclusive of the legal profession. It's a general problem of Nigeria. First, we don't have hand in training those we recruit. How is secondary school education? We remember the days when you say cut-off mark. For the worst university in this world, cut-off law, medicine, 280, 290, 300. Cut off. Now you hear the 280, 290, 300. So what used to be cut off is now the highest score of those we are receiving from secondary schools. And remember, there was a time we used to hear 200, 200. You know, university will admit somebody to come and read law with 240, with 230, 220. Now, you know that pass mark in JAMB, at least from the last exercise we went to Abuja with JAMB, it was a debate for university. The debate which we put to vote was between 120, 130, and 140. And some of us insisted on 140, 150, 140 carried the vote. 140 made the highest vote for universities. So we are being fed from secondary schools. We are being fed from secondary schools. So pass mark to enter university now in Nigeria for this year is 140. Have you seen why I'm saying it's a problem of the system? So our duty in the university now is to elevate that 140 brain to 300. Almost an impossible task. Now, for the legal profession, we started discriminating on those to enter into the legal profession by virtue of secondary school qualification. In our own days in the 80s, it used to be English, 5 credits with English compulsory. At a point, some universities introduced literature. I know when I entered the university, it was English and 3 other subjects. And you see people who took mathematics, physics, English, and biology in JAM to read law. We had the opportunity of getting the brain from any end. If you can read law, come and compete. But now, the qualification to read law is now more on the exceptions. And even JAM introduced what they call subject combination. So that if you want your child to read law, make sure you follow closely the JAM brochure to know the subject combination. So after JSS 3 into SS 1, you have self having made the which you cannot change later. Because you now discover that to read law is more of an exception. There must be English, there must be literature. In most universities, there must be mathematics. I'm talking about credit. 5 credits you are required. 1 other science subjects. Then one course will make it 5. It's no longer English and any other 4 subjects qualifying for minimum entry qualification. Now, we have more universities now. Despite that, it's not enough. We have 2 institutions regulating the teaching of law in Nigeria. NUC and Council of Legal Education, where my organ made substantial inputs in life. They will come for inspection. NUC will tell you, look at the ratio of staff to students. Look at the ratio of this to this. They will see your library, they will see all these things. And then you will either be given full accreditation or partial, which is 2 years, 5 years. Council of Legal Education will come to check the environment where you are teaching the lawyers to know whether this environment is a worthy place to teach those who are to enter into this profession. At the end, these 2 institutions allocate to you 100 students as your quota. By your capacity, what you displayed, a combination of the halls, teaching halls, a combination of teaching equipment, a combination of lecturers you have, a combination of all these things. They said your quota is 100, 120, 150, depending on what they saw on ground. The moment they turn their back, the vice chancellors, probably due to pressure from the government house, House of Assembly, pressure from friends, relations, every professor in the university wants the child to read law. Every person wants the child to read law. You now see 100 spaces. You see more than 2,000 persons in JAM subscribing for the 100 places. Now, how do we do it? We come for admission exercise. JAM said by their record, 100% merit will go to 10%. So 1,500 persons had their slot for your institution. 10 will be merit. Then catchment. All the words, you will know them, manufactured, they had their own percentage. Finally, university will do PR, and all these things will be there. So you now see out of 1,500 that put JAM to read JAM, you have 10% who are the people with the real brain. Remember, the brain had been reduced from 300, 280, down to 140. You now have 10% in that other merit order list. Then whom do you fill it with? Out of that 10%, you find it ending with around 260. The rest of 90, you fill it up with children who fall into certain categories. If not spread, it will be catchment. If not catchment, it will be government house. If not government house, it will be house of assembly. If not that, it will be professors' children in the university. You feel. You now find somebody who scored 250, 260, not getting admission, but somebody who scored 170, 160, being admitted because of these things. Now, you are having a problem trying to train a fit-for-purpose lawyer, somebody whom it is very difficult to redeem, somebody that is irredeemable. And then, to withstand pressure, to settle more friends, to accommodate more people, the vice chancellor, and most times corruption. The vice chancellors now move beyond what they were allocated. Remember, Council of Legal Education and the NUC had allocated to this university, say, 100. Because of your facilities and because of the number of teachers. But you now see the vice chancellors moving out to satisfy the yearning, the demands of the entire public. You now see them accommodating into law, I'm rounding up, sir, 400 students. Now, your facility to train the fit-for-purpose lawyer, your facility to train them is 100, can accommodate 100. Then they will admit 400. The same number of staff, around 20, training 400. Cross it across board. 400 times 5 classes. That is 2,000 human beings being trained by 20 staff. With a sitting capacity of 100. With what ability to mark? What motivation? The lecturers will be there, grudgingly teaching. Now, for you to train a fit-for-purpose lawyer, there must be a communication. There must be a relationship. There must be one-on-one. And you see had it to 1:30 students. There must be one-on-one relationship between the class, teaching class, and the student class. How can that one-on-one relationship develop in a class of population of 400, designed for 200, to be taught by class of lecturers designed to accommodate 100? Gentlemen, tell me whether it is possible in Nigeria for us to have fit-for-purpose lawyer. Thank you very much.
Thank you. So that's cancer now, cancer. And there's no cure for cancer. We're in trouble now. And you remember, this is coming from a VC, not an assistant lecturer now. It's the VC that's telling us this background. So thank you, Yuyu, for opening up that discussion very, very well for us to begin to think and reflect while we are discussing. I will continue the discussion by asking Wamaka, Doctor, to deal with the some aspects of the same thing, maybe ethics from that aspect.
Thank you so much, Prof. My seniors, the professors, my PhD supervisor, it was Prof that continued to make me what I am today, because, and each time when I see him, he normally forgets. I don't know, Prof, if it's because I changed or what. And I always go to introduce myself to him.
I will not forget again.
Yes, sir. Why I said so is, if you are an academic, before you can rise and be a senior lecturer, you must have your PhD. If you don't, you'll be there, waiting, while the others will come and leave you there. So due to some reasons, which Prof mentioned, I got delayed. But Prof came as a messiah and helped me out. So I'm grateful, sir. Now, my own part of this is ethics. Fit and proper lawyer vis-a-vis ethics. Now, you know that legal profession is an enviable profession. In fact, I studied law because I used to see my father, who was the late judge. He was spotless, the way he dressed, the way he spoke, the way he conducted himself. They said then, Justice Umezinwa of blessed memory, said he didn't take bribe. We were not as rich as we could have been if he had taken bribe. You know then, 80s, you can imagine how much they paid judges then. But we were still okay. I looked at him and said, I like this profession. I want to be like him. I want to be a lawyer, and I want to go up. So why I say this is a profession people outside look up to, people that are not opportune to come in. They envy you. Lawyer. How come? During my secondary school days, when we graduated, I was the only one that got admission to read law. My schoolmates were so excited. They were like, Amaka, now wow, you're lucky. I told them I knew what I wanted, and I went for it. Good. Now, being a lawyer, we know we have various ethics. These ethics will help us to conduct ourselves in this practice of legal profession. When you look at a lawyer, you watch his dressing, the way he speaks. You watch his conduct in court. When you come to court, you marvel at how lawyers address judges, at how they address their colleagues, what they do in scouting for briefs, you know? And it really amazes me. It amazes us. But it's because of the economic condition in the society. But that is not a reason. Some do not know. That is why I'm here. Are they aware of these various ethics? Are they aware that you should have a client's account, that fee, that client's property that you manage? Must you put that money in your personal account? You know how people and money are. How do you manage that account? Should you put it in a client's account so that you know that the only thing you have there is your 5% or your 10%? But when you see the money, millions there, the millions there, you feel you're in control of it. And when you spend it, what happens? Should you spend it? Should you insult judges? Should you dress properly? Should you look for clients? Should you run after briefs? These are the ethics, and etc. And remember, when we behave well, that is when justice is achieved. That is when we help the government and we help the society. You know what happens to corrupt lawyers? I come from our nature bar. I know in all the various branches of the bar, you have disciplinary committees. At times, I'm sure that when I hear so lawyer went to disciplinary committee in respect of a client's property, money, you see lawyers that are being petitioned against, and they are sent. The police will come and insult you and pick you. Is it all these things, are they proper? The answer should be yours. But why I'm here is in respect of the fact that I'm a lecturer. How do we help these young ones? These young ones that we teach, do we tell them enough about these ethics? Are they exposed? Are they aware? Now, the question is, at what level should professional ethics be taught to a law student? At what level? Should it be at the university level, which is 5 years? Or should it be like at the law school level, which is just 12 months? And remember, the 12 months, you have a court attachment and chambers attachment. And mark you, at that law school level, you know what they want is for them to pass the exams. Is that not so? Yes. So, I feel that these young ones should be taught professional ethics at the lower level. There are a lot of pros and cons. People that are for and against teaching of professional ethics at the university level. Some said that it's very good, that will expose them to practice. They will know the professional code, conduct of the profession they are about to enter. Some said, no, that the professional ethics is morals, that before they come in, they have formed their moral. But what of the fact that when they come in, you have to teach them morals, ethics of legal profession? So I feel, with respect, that there should be curriculum development. Curriculum development at the university level so that you can include discourse professional ethics. And making this suggestion, when I developed, I stated some overviews, things that will come under this professional ethics as a course, an overview. Under that, the students will be taught the duties of lawyers to clients, law office management, discipline of judicial officers, lawyers' duty to court, legal practitioners' account rule, remuneration of legal practitioner, advertisement and improper attraction of business, regulatory and controlling bodies of the legal profession, discipline of lawyers, advocacy practice. With that, these young ones, these beautiful souls who are always ready to learn, they are so always ready and eager to learn. I remember I teach land law and conveyancing, LDC. When I come to the class, and it's what they see, what you teach them and what they see, I make sure I dress very well. So when I come to the class, I tell them, look at me, look at my dressing, look at my shoes, look at what I'm putting on. You can make it in legal practice. I am here to teach you legal drafting and conveyancing, which is drafting. You can draft a letter. It doesn't have a fixed price. So I'll just tell them this. I can just draft a letter. It depends on what you agreed with your clients. So if we can, at that level, either at fourth year or fifth year, legal method at year one is not enough. Either at fourth year or at fifth year, we introduce professional ethics as a course and make it compulsory. Thank you so much.
That's wonderful, Wamaka. Thanks for that brief presentation on ethics, integrating ethics in our LLB curriculum. And we will need to reflect on that. Are ethical lawyers born or made? Are ethical lawyers born or made? We'll get back to that discussion in due course. We'll roll on by calling on Victoria to tell us, to share her experience as our oldest lawyer here.
Good evening, everyone. Okay, thank you very much, Prof. Thank you to every member of the panel, and thank you to the MBA Organizing Committee for this opportunity. I do not take it for granted. I'm glad that we've had lecturers go ahead of me, so I do not have to touch on those issues anymore because of want of time. So I have about 10 minutes. So I would like to break what I want to say down into two major points. What are the issues from the practical perspective? I was called in 2021, that was last year. I made the first class from the Nigerian Law School. But I still had a lot of challenges when I got my job with detailed commercial solicitors. So I'll be addressing some of these challenges and I'll be making some recommendations. I spoke to a number of colleagues on the issues they faced and they faced in their first year and in their earlier years. So the first thing I would like to say is that we recognize the effort of lecturers and the Council of Legal Education and the law faculties in curating legal education for lawyers. I understand it is very easy to critique. It is very easy to make recommendations, but it is very difficult to implement. So we recognize the effort. I also like to recognize the fact that law school and the legal faculty cannot teach you everything. That is another thing we recognize. But is legal education at the moment fit for purpose? I don't think so. I would like to give an analogy of law is a very practical course. So for example, a mechanic, maybe 20, 30 years ago, knowing how to fix a Mercedes V-boot or a B2 vehicle was fit for purpose, you were probably a top-tier mechanic at that point. But if that's the only knowledge you have now, knowledge on how to fix a V-boot or a Volkswagen Beetle, you are no longer fit for purpose. And I think this is the issue with the legal education. My personal belief and opinion is that we are not producing 21st century lawyers because legal education has not evolved as fast as it should have. And some of these issues I will be emphasizing will be that legal education doesn't particularly take into consideration what we call modern trends. For example, fintech, cryptocurrency, things of that nature, climate change that affects everybody. I don't think legal education in Nigeria has caught up to it. Okay, let's say environmental law universities might be taking care of this, but is it sufficient? So that's one of the issues. One very common example is how we are taught to draft CVs in the law school. The first thing I was told is that just learn it for your exam. If you submit that kind of CV to like Banwo and Igodalo, nobody will call you. And this should not be the case. This is one of the issues we are dealing with. I also like to talk about how legal education at the moment is very dispute-focused. I'm a solicitor with detailed commercial solicitors, and people ask me, you don't go to court, so what do you do? Not just people outside the legal profession, people within the legal profession. They say, okay, so you're focused on arbitration. We say, no, we don't do dispute at all. But we do something as lawyers. We do a lot. I am constantly busy. So law is bigger. That's why we are called as barristers and solicitors of the Supreme Court. We should not only be trained as barristers. We can say, okay, yes, there is property law practice and corporate law practice. But I can say for a fact that knowledge of karma is not all that is corporate law practice. Knowing how to draft a lease or knowing how to draft a quit notice is not all that is property law practice. What happened to taking security? What happened to knowing about the debentures, account charge, loans? What happened to these things that we deal with face to face? So lawyers have to plan and go to very good firms because your employers for your first to third year will teach you 95% of what you use in practice because legal education does not prepare you for that. So these are some of the issues we deal with. Now, it is not enough to talk about the problem. We all know the problem. So what can we do about it? So there was a legal education summit sometime in April, and the communique has been shared where a number of recommendations that I applaud have been included. We can look that up. But I have a few things to add. The first thing I would like to add is that those who do should teach. I don't believe there should be a dichotomy between academia and practice in the legal profession. Law is very practical, and that's why I'm very happy to be on this panel with people who are not just lecturers, because I looked up the panel. I know that these are people who practice. So their approach to teaching will be different. You cannot teach students, you can't teach and prepare students for practice that you are not familiar with. You cannot do that. So I believe that there should be no, I'm purely academia, I don't practice. You can't prepare students and young lawyers for a world you are not even aware of. Again, I would like to call for a revamp of the curriculum. For example, I would like to give an example of professional ethics and skills, which I think at a point was law in practice. So I understand that law is a legal profession, a higher calling, a noble profession. Yes, but law in practice should be more. Law in practice should prepare you practically for what you meet in practice. For example, corporate communication. Nothing in law school prepares you for how many emails you will have to send, how to have virtual meetings, or even how to have normal meetings, client meetings, especially when it comes to corporate commercial law. So corporate communication, project management, client management, financial analysis, mental health, work-life balance. These are things that law in practice should begin to look at, because it's not just ethics. Ethics is fantastic. I think ethics is the bedrock of this profession, but law in practice should be more than that. When I go to corporate law practice and property law practice, the first recommendation I would like to make is that the Council of Legal Education should collaborate with the NBSBL to rework the whole syllabus so that it is something that works. Because at the moment, it's a lot of theory. Let's relegate all theoretical thoughts to the universities. And let's deal with practical things at the Nigerian Law School. And from that point, I also want to make the point of law, again, is practical. I think this is the core of what I'm saying. So when we deal with courses in the universities that do not have any practical application, they should be phased out in their entirety. If you will not use this course in legal practice at all, we should not be taught. Because it's a very short time frame for us to spend teaching students what they will not use. Then I also like to comment on the fact of those who should teach. I understand that our schedules are like very tedious. So it's not particularly practical to say you want to get top tier lawyers to come in every day to be teaching students from scratch. It's not practical. So I thought, what can be done as a band-aid, pending the time there is proper reform in the legal education system? And I was like, probably 2 weeks during the coursework period. 2 weeks out of the whole 14, 15 weeks of a semester. It should be just practical knowledge. The lecturers can teach 10, 12 weeks, but for 2 weeks, they should get a top-tier lawyer, someone who specializes in that. If it's criminal law, get someone from the Ministry of Justice. If it is for commercial law or contract, get someone that does this thing on the highest level into the university to teach them that, okay, these things you've done for 10 weeks, this is how it works in real life. These are some of the things that I think should be introduced. I also like to point out that legal education is not the work of the Council of Legal Education alone. And this is the point I will close on. It's the job of everybody. And that's why I'm excited we are discussing it here. Because we cannot say Council of Legal Education should just do the work alone. They should be in bed with every professional body of the legal profession. The MBA, not just, we can't leave this to just the Council of Legal Education, especially because we know what manpower do they have to train how many lawyers every year. So as we are here, we don't need to challenge ourselves at our firms. If the MBA calls on your firm to donate a lawyer in quote to take a course, will your firm answer? These are things we need to start thinking about. I think I'll have to end here because I've gone over my time. Thank you very much.
Yes, I like to hear that perspective, you know. In all the programs I tried to do many years back relating to legal education, I always prefer to have the speakers, more than 50% of the speakers are students, more than the people in practice, because they bring it live to you. So thank you, Victoria, for waking us up again to the reality. And with that transition, I move over to Larry SN to tell us about what employers can do or are doing in relation to this cancer raised by you, Chukwumeze, and which other colleagues have told us how they manifest on our bodies. Larry.
Thank you very much, Maegmon, Press Ojuku. Thank you. You've always been a trailblazer. We appreciate you, my colleague, VC. Thank you very much. My very respected other panelists, the Amazons in our midst. Let me thank this great audience because I know the plenary session is on. So for being a part of us here, it shows your interest in legal education. Thank you very much for committing the time to be here. Thank you so much. I will say that Victoria actually delivered my paper. So what I'm going to be doing is give the footnote to what Victoria has done. And I will tell you why. Oh yes, brilliant summation. Because yes, the problems are there. We know the problems. So what solutions can we bring to bear? And it is for all of us. We should stop the complaints. The complaints will not go away. And there is no magic wand that is going to come immediately and take the complaints away. But if we are intentional and deliberate, we can make a difference. I'm talking from the perspective of what I've experienced. I knew how I met the Lagos State University. By the time I was leaving the Lagos State University, it was adjudged by Times Higher Education as the second best university in Nigeria. So it is possible to make a difference. It is possible. Now, I'm going to talk from the perspective of what Ruka & Co. is doing in terms of trying to meet the gaps that we have in legal education. I know my time is 10 minutes, so I'm just going to run down a few things, and I'll allow the conversation to bring out more of what we're talking about. At Ruka & Co., we engage with those who are coming in and those who are already in the firm. And I'm going to be sharing some nuggets on what you can also do in your space in managing this. Starting from the recruitment policy of the firm, we don't go by class of degree. We are interested when we are recruiting in whether the person we are bringing in is trainable. It is not about class of degree. It is about competence fit for purpose. We are not looking at it that, yes, you are already there. But we are looking at it that, are you the kind of person that we can train if we come into our midst? That is what we qualify you. So we are looking at your character. And that dovetails into the ethics that my colleagues are talking about. We're looking at character. We're looking at personality. And that is what we will add to your basic knowledge. When we look at it that you are trainable, then you have crossed that Rubicon and you go to the next level. What are these other things that we do? We will identify your interests at the point of interview, so that if we know that you are interested in technology, we are going to be supporting you, encouraging you, working with you for you to become an expert in that field. And we'll be pushing you forward as the expert in the firm who can work in this area, and also supporting you with all the necessary things that can aid you in that activity. In addition to that, there's a Friday chambers meeting that we do. And I know that almost all law firms have a day in the week. It's usually Wednesday, Thursday, or Friday, when they sit down. And what they do is to prepare for the coming week. There are 4 critical things that comes up on the agenda of Look & Co. every Friday when we meet. The first is the in-house advocacy segment. What do we do at that in-house advocacy segment? If we know there is an application or an appeal brief that we are going to argue in the course of the following week, or there's going to be a trial, we'll simulate 2 teams. And it does not matter. We are not necessarily going to pick those who will go and argue the matter in court. We will pick any of the colleagues in the chambers. The 2 of you will be the appellant. The 2 of you will be the respondent. The 2 of you will be the applicant. The 2 of you will be the respondent. And they will articulate and argue that brief or application in chambers. Other lawyers will be able to give their own comments in such a way that is constructive. Whoever is handling that file will coast home because the issues will have been articulated at that chambers meeting. A second thing we do, there is the segment on contemporary legal issues of interest. Any issue globally, within Nigeria, outside Nigeria, that is topical, we will bring it to that meeting, we will talk about it, we'll bring out all the perspectives. A third one, mandatory presentation on cases. You will pick a case of your choice, but there must be something important about that case. Maybe it's a locus classicus of a sort, or it is changing the face of the law, or something that the Supreme Court has not done well. You will come to that session, and you will make a presentation. I will encourage you not to read the report. You are going to summarize the report and tell us what is the ratio of that case. And at the end of the day, we will also be able to contribute. All of these are part of what we're trying to do to improve the advocacy of counsel, improve their critical thinking, and also ensure that we deepen their confidence level. A fourth thing that we do, there are 2 counsel that are appointed who consistently monitor updates in the law. What are the developments in the law? In the course of the week, they will bring out all that has come up. In some week, nothing may come up. And they will just say, oh, there has been no new law. But if there is something that the National Assembly or a state of assembly in any state is discussing, and we find it in the newspaper, they will bring it to their attention. So that anywhere you are, any crowd where you are, everybody, the moment they say something, you have a knowledge of it. Even if it is a fleeting knowledge, as of that time, you'll be able to say something in relation to it. Then we organize regular webinars where we bring in experts. For instance, my Egbo here, we'll ask him, come and talk to us at Look & Co. He will come in. We'll bring in Professor Chukwueze. He will come in and talk to us. Those are the kind of things we do. And it will be anywhere he is in the world, he will be able to relate with us because COVID-19 has taken away all obstacles and barriers to knowledge development. So nothing should stop us. Then, there is what we call the learning retreats. The learning retreat is when we go out of the law firm and we go to a place of interest and we just sit there and we allow ourselves to dialogue and discuss on issues. Then we believe strongly that remuneration packages is important in encouraging counsel. So while we cannot save the world, but we can do our own bit. So in some little ways, we want to make sure that remuneration is not unreasonable. Again, there's a way we address ourselves in the office. Because one of the things you must do is to ensure that there is nothing like formality that will allow people not to be able to talk. Abimbola will be addressed as AS. You take the initial and you take the surname. AS, PE, UI, TO. They call me LF. Nobody will say prof, they will say LF, and we are able to talk without any barriers, and people are able to be constructive in whatever they say. Another thing that we do, outside of those lawyers who are in the office or those lawyers who are already in practice, we go out to the universities and we encourage interns to come into the office. And when they come in, we are trying to teach them the culture of the law firm, so that by the time they graduate, some of them will end up in our law firm because they have been interns with us over a period of 1 or 2 years. So we do that from time to time. Then we also organize essay competition. We pick a topical issue and we allow students from the different faculties of law to be a part of the competition. And the best 4 students, we bring them in aside of the monetary award that we give them. We also ensure that we go ahead and we give them internship slots. What I will say in closing this is that it is not just about complaining. We all have a role to play. Nobody is coming to do Nigeria for us. Nigerians will have to do Nigeria. Nigerians will repair Nigeria. We will not be negative about Nigeria. We will correct this and we will get there. I thank you so much.
Oh, Larry, that's good. At least you have given us hope again that we are all going to be alive. From the cancer to hope. Not that he has given us, not that we have actually going to get cured, but at least you have hope while you are dying. There's hope. That's a great one. And I love that this effort, and of course I know what you have set out to do. There are people who run law firms just for capital, packing capital home, and those who run law firms because they want to also put their own positive into the system. Thank you for that. I'll just ask them a few questions, then I'll throw it up for us to contribute or ask questions. I'll ask you, Chukwumeze, for example, to tell us a little more about how we can tackle some of these problems. For example, I love to recruit young lawyers and give them opportunity to decide what they want to do, because I know the greatest problem young lawyers have in their life is even career decision making. It's very difficult to make a decision in the limited circumstance we have. So you don't need to stand up unless you wish to. You can talk from your chair, because just for 1 minute or two, and so on. Now, I have 2 lawyers that I employed some years back from youth service. One shared with me her experience with her supervisor in one of our universities. The supervisor insisted that she must pay for her project. She has not written it, but you have to pay in advance. A few of her colleagues who refused to pay and wrote the project never made it to defense. The faculty never had the opportunity of deciding whether to mark it or not. He just refused to allow the project progress beyond the hands of the student. Now, so she decided, okay, since I don't want this trouble, she paid. And for her and the teachers and the students who pay for that project, the teacher writes project for them or pretends to write for them, because what he does is to go bring old projects, change the name of the authors and amend the topic a bit and give it an A. And it happens year by year in that university. And the students know, the teachers know, everybody knows. Another person I also employed a few years ago wrote typed his project in, because one of the things I do, of course, if you join my firm, if I'm walking past your office and I see you writing in longhand, I'll just bring out a knife I have in my pocket and cut off a finger from your hand. Because nobody writes in longhand around me. Because I started typing all the things I published in 1991, 6 years at the bar, when I was one of the earliest to computerize myself without training. 1991, when we were using DOS, not Windows. Windows came 5 years after. Yeah, so if I see you writing in longhand, I cut off that hand. And the students these new lawyers were shocked. Each time I get them, they are shocked to hear that somebody cannot write with pen. You must go, because you come in, every table has a computer in my office. So you must go straight and start typing whatever you're doing. Your thoughts must be typed straight, not retyped later. So that's the first shock they have. And so after that experience, he now told me his story about his dissertation in this other university. He typed his dissertation and presented to the teacher. The teacher rejected it and insisted that he must write it in longhand. So he went back and recopied all the things he typed in longhand. And then the teacher now accepted it. And of course, when you write in longhand, you will never even have opportunity as a supervisor to look at plagiarism rules and so on and so forth, and the footnoting and referencing how the styles has been presented. You will never see all those things. And that teacher is still a teacher in the university, and he still does that today. What do we do with such lecturers in university? Now that you're a VC, what do we do?
Thank you, my master. I will, you asked me basically two questions. I will end up with the last one. The first one is to make suggestions on how we move forward. I have already said it that we should make English the only compulsory subject to read law. Any person can come with any subject as long as it's up to 5 credits. Whether mathematics, literature, those things shouldn't be compulsory. And then NUC and the Council of Legal Education and the legal profession must be strict on a university that overshoots its quota. If possible, close down that faculty. It will be a very difficult thing. I can't see how if you are allowed to admit 100, you admit 400. Meanwhile, you cannot employ. Year in, year out, no employment. And then, on the issue of corruption in the university, I thank God that you taught me. And I thank God that if you meet 100 of my students and 2, let me not say 1 because God takes precedent, 2 says I am corrupt, then count you, Chukwumeze, as a corrupt man. And in my university, now I say this now because there are some of my colleagues here, I have just introduced a new thing. I've equipped my anti-corruption unit, which I call, or which in the academic circle we call quality assurance. I've gotten my ICT unit to open an email, which we call anti-corruption mail. The moment we strike is over and the students are coming back, they'll be given the email. Make it anonymous if you want. Write your name if you want. If you see any iota of corruption, selling of books, collecting money, sexual harassment, any iota of corruption, the students should go and put it into that mail. They leave the rest for us. I told the governor when he appointed me, I told the council, that if I lack the will to enforce, to fight corruption, it is better I die. And I think you know that. Thank you very much. So please, the email has been opened. We are waiting for the students to come back. Every student will have it. collect 1 naira from any student. The student will just go there and type, this lecturer collected 1 naira from me. Then you will see what will happen. Thank you very much.
Thank you. Thank you very much. Let's ask Larry to see how do we replicate these aspects of the law firm's intervention post-call, which is necessary, because nobody is going to train any person at LLB, even after law school, to become a lawyer guru. We're only preparing you, just as we do children, to learn how to crawl and walk and talk. We don't train children at 1 year to learn how to come and present like Larry or Yuyu or Victoria on the stage. We just train them on how to stand and how to move without falling. That's all the aim of training at a 5-year and then 1-year program. But if we don't do it, this effort that you're making will be very difficult, because only few people with passion to contribute will put that much effort in the system. But the effort is necessary because it's a continuing education program. It's a vocation training. If you go, of course, many of you may have known too, as my colleagues here know, if you go to firms abroad, every 2 weeks, every 1 week, there's a training. One session of the law firm is undergoing one form of training. Every week, including the biggest partners. Every week, there's a training on one. Anything that comes out, for example, there's a training. A decision that shocks the world, the country or the nation or the state or the area of law, there's a training immediately, and so on and so forth. But without a transition from LLB through, it will be more difficult. How do we get this type of ideas working at the university?
Thank you. Thank you very much, Maibon. I'll just make a one-line comment on what the VC said. And I will say, whistle-blowing works. I utilized it. And what I did is, if you send it to me, I will not call the lecturer. I will walk to the office of the lecturer. It's an anonymous thing, and I will sit there. I'll say, Prof, all these girls that you have been asking to do ABC, all those guys that you have been asking to bring shirt, I'm fully aware of it. You make a choice now. Next time, I'm not coming to meet you. It is always reinforcing. And when I caught those who are involved in it, all of them were dismissed, including ASU leaders.
I remember when they were threatening you.
Yes.
I think they will kill you that time.
At the end of the day, some of us will follow the kind of things you do. So nothing will happen. Now, coming back to this other one, I think there's a need for the MBA to have effective conversation with deans of faculties. Deans of faculties are critical. For instance, in faculties of law, you find out that where there is effectiveness of the dean of law, a whole lot of things will happen in terms of clinics, moot court competition, and a whole lot of things that assist the students to thrive. One thing you summarize, sir, which I will emphasize, sir, is passion. Passion is of importance. Then, monitoring and evaluation now comes in. That is where MBA, Council of Legal Education. And monitoring and evaluation should not be a case of coming when they are expecting that you are coming. When they are expecting that you are coming and you go there, facelift and everything will be working well. But when I was there, I had a quality assurance team. And the only person I knew in the quality assurance team was the chairman of the quality assurance team. I told him, pick other members of your team and don't disclose them to me, because I'm also being monitored by the quality assurance team. And that galvanized everybody, because we didn't know who were the people there. And because I chose a man of honor, the man went ahead and picked individuals who are merit candidates. These are the ways, sir, that I think we can do it in the different systems.
Thank you very much. Thank you very much. That summarizes what we need to do. We need to have human beings as deans. But I can tell you that there are very few human beings as deans in Nigeria. And I know my boy Larry was one, and I know you was also one. But there are very few. There are hopeless people there. Hopeless. Amaka, what do we do to introduce ethics? You have spoken about ethics, and I know the broader form of ethics must include values, national core values, not only our rules of professional conduct, our principle of honesty, our principle of fairness and empathy. These are all lacking in the country now, even among lawyers. I see on WhatsApp group, people calling fathers and grandfathers fool on WhatsApp. Because it's not their political party or something. The lawyers use words like this fool on WhatsApp, on human beings. And when I get there, I say, look, but have you considered that this is your grandfather or father or mother? How will you feel if you are in a WhatsApp group and somebody else calls their father fool for whatever the person has done? Even the biggest Boko Haram terrorists. Where did we lose this? Our honesty, to decency. Kindness. What did we get it? What did we lose it? Empathy. When I tell people that if you don't join a queue, either as a car, as a driver, or pedestrian, or like in a hall now, if you're just asked to line up to get something and everybody's struggling to get it. If you don't join a queue and ask people, what is the reason why Nigerians don't like queues? They say because they are impatient, this and that. I said, but have you considered that the reason for that is dishonesty? It's not impatience. It's you're a dishonest person if you don't join a queue. It's dishonest because you want to cheat. So how do we get the investors? How is the investor going about it? What are we going to do to get an example from you or generally?
Yes, sir. Thank you so much, sir. There was a time we went for our conference, Nigerian Association of Law Teachers conference at Aigbe. So during the conference, various topics will be given to the universities to speak on them during the conference. So we, from the university, got the topic that has to do with curriculum development. And we were three, Professor Nyogu, Dr. Onyeka, and I. We spoke on it. We looked at this curriculum. I always say curriculum. We looked at it, and we found out that ethics matters, that these young ones do not get enough of it from the courses that they are being taught. You could say legal method. At the year one stage, when they are still so young and they don't really understand what they are there to do, because when you get to that legal method class, you start counseling, you start telling them the importance of passing your courses, studying, So, and legal method, there you see law and morals and the rest of them. So we said that these are not enough. Professional ethics should be a course. Teach them. They don't know. Yes. The question could be, are lawyers born or made? You could see people from a good background. They have conscience, morals. But you could see people who are not really from that background. When they come over, you teach them. And some that were saying that you don't teach ethics, that ethics has to do with morals, that they have formed the morals before coming. What about the ethics of legal profession? Have they formed it too? How would they know? So if the curriculum is being developed, if we agree at the law teacher stage, we'll make the presentation to the proper body so that this curriculum will be changed by adding professional ethics. And it should be made a compulsory course. Thank you, sir.
Very much. We'll ask Victoria last now. She's even though she's our oldest, but she's our baby. And so, even though she's not also the smallest, but we'll ask her last. Victoria, with all the things you have suggested and hearing your colleagues, what aspect of of a proposal will you present here that we can implement to help the transition of law students?
Okay, thank you very much. So I'm going to mention two important things. But the first thing I would like to mention is that from the youngest possible level, law students should be told what they can do with their call to bar certificate. Okay, you can go into government, you can be a transaction lawyer, you can do dispute, you can do arbitration, you can do mediation. Career prospects in law should be incorporated in the syllabus and in the curriculum. So people are not just coming out lost. I don't even know what I want to do. And then in NYSC, when they say come and do human resource and management course, everybody jumps on it. When they say come and do this, everybody jumps on it because people are not sure at that point what they even want to do. Yes, I understand that it's important to gather knowledge everywhere, but it's also important to be able to start picking electives that suit what you want to do as a lawyer. Not that you are graduating 3-4 years and you are not even sure, you didn't even know at any point in time that, okay, I can do capital market, I can be a solicitor, a capital market solicitor of some sort. So I think it's something that should be incorporated. And last point I have to talk about is internship and externship. Now, throughout my time in the university, I don't think I was ever told within the school system that you can do internships. I understand that there are some universities, like maybe Afe Babalola University, that make internships compulsory. But it didn't happen. Maybe I heard from my colleagues or my friends. This is what I think should be done. Law faculties should not only strongly encourage internship, they should facilitate it. You have alumnus and members that pass through the faculty that have become big deals in the legal profession. But we are not using these connections. The faculties are just sleeping on this. I think if you cannot make it compulsory, because some people are doing law because their parents said they should do law, not because they want to do it. But we can make it, we can strongly advocate for it and facilitate this internship. With respect to externship, I think externship is a fantastic idea, but I don't think it is fulfilling its purpose anymore. I didn't get to do externship because of the unique way we went to law school. But from the people I've spoken to, people are too busy within the extension period trying to finish the law school syllabus that they are not even paying attention. They just go and they want to escape as soon as possible so they can go and read corporate law practice or something. So that period just before going in for the final leg for externship, I don't think it's very effective in getting practical knowledge. Maybe it can be shifted to the period post-bar finals before call to bar, or maybe if the pupillage structure, well structured, not to exploit young lawyers, but to ensure that they are well trained, is adopted. But I think the point where we do externship for law students is not fulfilling its purpose anymore.
Thank you. We are going to end with your own contribution. So, please connect this. Take. There are many hands. You can start from the back. There's a lady there, but you can give the mic to any person you don't like. Give the person the mic. We will take note here. Yes, we will take note here at the end of the question. So please, colleagues, anything that may be directed to you, just take note so I won't go interrupting. At the end, we will now answer them. Yes, please, go ahead.
Good evening.
Well, sure, I will.
Good evening.
We will limit the number. That's why I told Bayon to decide who he likes to give the mic. But we'll start from the back there. He has already said 5. So maybe take 2 here, 2 here, 2 here, 2 here, 6.
Okay, good evening. My name is Yame. I want to thank you, distinguished panelists. I have a question for you, Mr. VC. Sir, how do you balance abuse with your whistleblowing policy? So, for instance, I do not like you. I put up a story that does not exist into your platform. How do you prevent that abuse? Then secondly, from the conversations, I see very deliberate efforts by the private sector, legal practitioners to build capacity. What ideas would you share with the public sector lawyers in terms of building capacity across their teams? Thank you.
Let's take one in front.
Thank you, sir. Good afternoon, distinguished panelists. I have one
We'll just take 222. If we have a little more time, we'll come back to 111 again.
I have one question and one contribution. The question is, Victoria correctly stated that if you have no business teaching what you don't know about, you're not in law practice. I always cringe in law school when my lecturers say, the law is this, but in practice, it is this. It was always a problem for me. My question then is, why have we struggled to attract our best to teach? And I don't think it's money. So the question is, what is it that is stopping us from attracting our best to teach? The other one is the contribution. I'll make it very short. I studied in Nigeria for 5 years, as most of us did, for my first degree, and was privileged to do 1 year in the UK for my master's. And I spotted loads of differences that we can, if we do, we would produce better lawyers. And they are very simple and don't cost money. So this is like a suggestion. One, and let me just mention one of them, which is in the area of our dissertation, which, Prof, you talked about. In my university, first degree, lovely school, issue I realized was that one person writes, or rather, all the students, he divides the students into different lecturers to say, lecturer 1 would supervise 10 students. Lecturer 1 is supervising somebody on land law. He's supervising someone on company law. He's supervising someone on criminal law. For my master's, what did they do? Students were asked to choose their supervisor. So you just send an email to a lecturer to say, and the school, first of all, tells you, look at our lecturers. Look at their areas of specialization. Write to any of them and say, this is what I want to write on. If the person is okay, you then send the person's name to the school. If we do that in Nigeria, you take away power from the lecturer, because it is those people who write names and decide who will be supervisors to students are the ones that will tell you if you don't pass, or if you don't give me money, or if you don't pay hotel accommodation for me, you will not pass your dissertation. This is just one of the various things I know that we as universities can do, and it will save our education system. You talked about dissertation as well. Loads of topics have been written in the past, and after writing, they will force you to print 5 copies of it. 500 students printing 5 copies. At the end of the day, they will go and store it at the back of the school. No knowledge, no contribution to society at all. It's a long day. I wish I had more time, but let me stop for others to speak.
Start from the back. I'll come back to you. The lady.
Thank you very much, distinguished panelists, professors, doctor, and my colleague. One contribution and one question. I'll follow his example, and I'll make it as short as possible. I believe, based on my own personal experience, that we cannot underestimate the impact of good orientation. I remember when I was in, I think, 200 level, I had the opportunity to listen to Professor Ojukwu. I think that was 2009, when he was trying to bring in the idea of legal clinic to my university. From that day, just listening to him, I had such an idea and perspective and expectation about law school. From 200 level, I was waiting for law school because of the mindset I was given. I mean, that expectation was not met, but we're not talking about that today. But I came into university and there was, you go to social sciences today, you go to English. No, we didn't know why we were doing what we were doing. We were just going because that's what you're supposed to do. And you're tired at the end of the day and you just have to prepare for exams. No proper orientation to prepare you for why exactly you are learning what. And if that is done early on, then you know why you're doing what you're doing, you know what you're putting in effort for, and you can do it properly. Now, my question now, because I have people here who are very well experienced, very well learned, and who have influenced life so much. Many of us here are product of that system that has taught mediocrity. I look at my colleagues, I look at people, I look at events that are organized in Nigeria. It's almost as if mediocrity is in our DNA. You know, people say, I'm sorry if I've offended anybody. People say that I'm honestly trying my best. And you look at that person and they look like they're honestly trying their best. But you go to other climes and people do better. I honestly feel like I'm trying my best, but I don't know. I want to do better. I look at my people my age, who have my learning, and they're doing better. What can we do to win ourselves or remove this mediocrity from our DNA? Per your advice.
Good afternoon, distinguished panelists. I have two questions, and they'll be directed to the Vice Chancellor and Prof. as an employer. So for the Vice Chancellor, sir, in chambers, if we notice, one of the biggest weaknesses of new recruits is problem solving. And this can be linked to curriculum and by extension, the marking schemes. So when they come in, due to the way they've been taught in schools, they are taught to answer exactly as it's been taught, stifling creativity and critical thinking skills. So for example, when new laws come out, what do the experts do? The experts understand these laws and critique it, because this shows the peak of appreciation of a topic. But especially in law school, you are advised that just write it this way. And if you go beyond the scope, you probably fail, and also in the universities. So how do we amend our teaching practice to encourage creativity in answering questions? And for Prof, you listed the measures taken in the firm to help build capacity for staff. And while that is applaudable, sometimes due to our regulatory regime in Nigeria, we can still be stifled. Because concerning skill, experience is the best teacher. So let's take crypto, for example. We have a bipolar regulatory regime. SEC is in favor of it, CBN is against it. And but through that, lawyers now are stifled. We don't know, we can't practice because crypto companies they don't want to come to the country because of this. Now, that has stopped us as lawyers having no skill in this regard. So how do employees, one, cope with this or innovate around regulatory obstacles? Thank you.
Thank you. People at the back, but I told you when you stay at the back, God don't go see you.
Thank you, the distinguished panelists. My name is U.C. Ekea. I practice with the law office of Yuch Kumeze, and also kind of one of the discussants. I will just ask a simple question and make a contribution. By God's grace, I will direct my question to the youngest and the most senior presenter, as the moderator said, and the teacher. Victoria, I think from your discussion, you made wonderful submission. But I'm considering that what you said should be more of effect of the cause of the decline in the profession, the legal education. Take, for instance, you wonderfully submitted that the mechanic that learned how to repair a Mercedes years ago, and now what is in stock or what is running is a modern vehicle like, let's say, Venza or whatever. Now, because he don't have the knowledge of the modern technology, he may not be confronted with what is trading. Now, the issue is this. You remember that when we are all in the school, most of us are taught based on what is obtainable at the moment. And by the time we left the system, we are not expected to go back to that system to be taught afresh. Rather, it is our duty to learn based on the modern development and what is at hand. Now, if I am taught when I was in school as a law student on what is obtainable in the legal field, and now I'm practicing, there are many new challenges that I have to face. I think I am the person who's supposed to take up the duty to now upgrade and fit to the current trend. Not necessarily that I will be called back to be taught what is obtainable in the system. Now, I also want to make this contribution. I think the foundation of the decline in the legal education is as a result of one forcing people who does not belong to this profession to be part of it because we want someone or want to have a lawyer in our house. Take for instance, to be a lawyer, to be fit and proper, there are some qualities of a lawyer that you don't even need to learn, but that should be part and parcel of you. Being a gentleman is not something somebody should educate you how to be, but you have to have the quality of being a gentleman. As simple as that. So if we introduce, I'm sorry to use the local language, an Agboro man, to be part of this legal profession, no matter how you train him, he will still display his character or conduct as an Agboro.
Thank you very much. My name is Deima Dibi, and my contribution will be very brief. First of all, thank you to all the panelists. I think the panelists have addressed the situation very well. We know the problems, and they have also proposed the solution, as the case may be. But I think my contribution is to all of us seated here, because we're all lawyers. And so the question is, who's a fit-for-purpose lawyer? And I would just like to simply state that learning is something that you should continuously acquire as an individual, right? You shouldn't just depend on the schools, the university, the law school, and even your law firm to teach you everything that you need to learn. In order to be a fit-for-purpose lawyer, you need to continuously develop yourself. Education is an asset that can be simply acquired, and there's a vast repertoire of knowledge out there. The internet is out there for us to access. There's YouTube for us to learn everything. There are free textbooks, there are libraries. There's a lot of resource materials that you could actually use to learn. So it's, in a way, a recommendation and also an encouragement to all of us seated here that as lawyers, you should continue developing yourself as an individual for you to be a fit-for-purpose lawyer. Thank you.
Thank you very much. Thank you very much, Prof, and all the learned panelists. 3 comments. First, I have cited some branch chairmen in the midst, and I will start with that. The MBA can shout all they can on the decline of education. If the bar branches are not interested in what happens in faculties within their jurisdiction, we'll keep on going down. The market is being regulated by MBA, is our association. But if we do not carefully determine who belongs to our association, we'll keep on receiving whatever they give to us. So branch chairmen of the MBA should go beyond, okay, take for instance, in LOSA politics. Law students come out knowing how to play MBA politics very well because the branch leaders mentor them on LOSA politics, but they don't mentor them in legal practice. And that is one aspect. The second is we can't talk about legal education without talking about the law teacher education. Not every lawyer is a teacher. Not every lawyer is a teacher. For you to be a teacher, even if you were not born a teacher, you should undergo some training. So many of us are just employed as teachers, sent into the classrooms without any form of orientation, no form of training. MBA should get interested in this. Again, I will say on the issue of ethics, I so much appreciate that because Professor Ernest Ojukwu started an undergraduate level program called Ethics and Professional Responsibility, and it's a mandatory 200 level program at Bayes University. Last week, I was speaking to an international conference, and I asked, out of the 18 lecturers, law teachers who were there from Nigeria, none of them had ethics or had any component of ethics at undergraduate level. And that is not far-fetched. The NUC BMAS does not even in any way acknowledge that. But I asked and I said, there are 2 universities currently that are doing ethics at undergraduate level, Bayes University and the Redeemers University that started doing that last year. Now look at the curriculum for ethics at law school. It is basically law in practice, like Victoria said. 90% of what is being taught there is deceive you, they teach you how to write, you can't even use it. It's not working. So I will make 2 propositions. One, that we encourage Dr. Nwamaka in her proposal. I will join you, Ma, in every effort to see that we bring ethics to undergraduate level. Let's deal with ethics and professional responsibility. And this goes to issues of values, not just teaching them the rules of professional conduct. Then when we go to law school, we can know that we are teaching law in practice and not say we are teaching ethics when there is nothing ethical about it. Finally, the teachers who will teach this ethics, the lawyers who will want to be in, who are practicing, who will want to bring in, there must be ethical lawyers. There must be ethical teachers. So are we bringing in people who are not even interested in ethics? You tell them to teach ethics and they come to the class and read rule 1 of the RPC. The whole class echoes the rules and they go without passing down any knowledge. Thank you very much.
Okay, that's the last one. That's the last one. I've allowed him to speak because of his bias. It's like Chukwumeze's own.
My prof, I want to appeal for Dr. Abdul Rakim to speak after he speaks. Thank you very much, my prof.
Good afternoon, Prof. My name is Endurance Agbo. I'm an energy and natural resources lawyer. I also do a bit of private equity and IT. Since 2018, I have taught oil and gas law in the University of Calabar. And I dare add, for the past 2 years, that has been for free. I would like to start by buttressing the point that the last speaker made with regards to introducing ethics in our universities. Shortly after law school, I was pretty wet behind the ears then, and I'd been recruited, I think a year or 2 after, to start teaching oil and gas law at the University of Calabar. I had a conversation with the dean at the time about the need for us to introduce ethics amongst other courses into the curriculum of the university. Because I thought, just like Victoria said, that our curriculum wasn't fit for purpose. It was shut down immediately, right? Now, I do not understand, I don't fully appreciate the extent of latitude our faculties have to extend their curricula, but I would like to think that if the dean has some powers in that regard, then it is necessary for us to begin to collaborate with some of our alumni who have cut their teeth in various spheres of practice to be able to contribute to the development of the curriculum in our universities. For instance, I'm heavily involved in the startup space. I have a few startups of my own, primarily of which is LawYap. Now, what I have come to notice is, as developed as the Nigerian startup space is becoming, with VCs being interested in startups and more lawyers does, right? And I don't think that is responsive enough. And I would also like to think that one of the reasons why even students within the faculties cannot make any suggestions whatsoever is that there is a culture of fear in the law school and in our faculties. You would hear everybody tell you.
The truth is that unless we set out early to begin to put them on that path, so that along the way, let it be that it is by divine providence they will fall apart. I didn't make it, not the fault of the system. We head nowhere. She spoke brilliantly. She tells us what it is. All of us were thinking that way at some point when we were coming up. But then the reality is here. I am a professor of law, but I have been Attorney General to 2 governors in my state. And I tell you that there are issues. I also employ some of the highest number of lawyers in my law firms, 2 of them, or 3 in our branches, between Kefi, Lafia, and Abuja.
And you are also a dean.
Yes, I was Dean of Law and also President of our law teachers. And I haven't passed through all these experiences in life, both as a teacher, a law practitioner, and now an enforcer on the other side, on the government's side. We really need to work on our lawyers. We need to begin the weeding process early. He spoke very well about the fact that our admission process ends up with not really the best, not so fit for the profession. And I think that's the point. The moment we don't get it right from the admissions, I mean, all of us become enemies of the public once you are a dean of law. Everybody wants you to admit his child, whether he's qualified or not, starting from your colleagues. There was a time when I was dean that my colleagues came and surrounded me in the office. For God's sake, my quota was 40. I had 1,500 applicants that sat for pre-qualified exam. All of them qualified. Well, how do you admit 40 out of this number? Your colleagues in the faculty alone are standing behind you, breathing behind your neck, that they're going to beat you up or they'll impeach you the next day unless you admit their own candidates. And from there, you won't be able to get it right because the competition is stiff. He spoke about all these other interests who all want their own chances to be considered. It's a reality. Now, sir, that is the beginning. It also dovetails into employment of lecturers. And in the process of the competition, the scarcity for jobs, everybody sees lecturing now as the most prospective employment. The pay is not so bad comparatively with other government employments, comparatively with what lawyers are making in practice. Some lawyers are still not being paid anything, or even 10,000 in law firms. Teaching, is big deal. So the competition for it too, you will now have all these other considerations about the governor's list, about the speaker's list, house members are hanging behind your neck as VC, and so on and so forth. And then your colleagues from within, professors' children, who will tell you didn't come here to sell salt, so you must consider their wives, who are also trained as lawyers. You at the end of the day, end up with 80%, not necessarily those who are fit to teach. So there are many things that we face. For me, I have seen the five-dimensional angles of the environment, and I tell you, unless we rise up, I liked the way Prof ended his speech by giving hope. I'm one person who is very hopeful. But it is a hope that we can only actualize if we work and do it ourselves. From within, not from without. And it is doable, and we can achieve it. Prof, you remember, I had to go to your house to beg you to come and handle a module in the Faculty of Law. I had to break the faculty postgraduate program into specializations so that we can begin to change the psyche and thinking of lawyers. We set up 17 specializations. We didn't have the lecturers. But we have people like Prof and hundreds of other eminent professors of law staying in Abuja looking for opportunity to serve, to contribute. When I went to his house, met my lord, his wife, and him, and I gave a letter, I pleaded with him. He agreed. He still teaches in the faculty free of charge. When he knows he can't come to Chefi, he invites my students to his office. He teaches them there and he gives them coffee free. And then he marks the exams and gives us the results. And we did the same for all the modules, all the specialized courses, entertainment law, sports law, energy law, solid minerals law, all the areas of specialization that were introduced. The idea was to now begin to launch our law graduates who are lost, who have no idea of what to do with their certificate and their lives, to find something to do, to find a perspective and a direction. And that's what we're doing. The person who spoke at some point, I think he's one of our students. He's one of our postgraduate students, quite a number of them. All we're trying to do is to sharpen the edge of the knowledge they already have. Thank you very much, Prof, for your commitment to service, commitment to the profession, your mentorship to all of us here. So thank you, sir. And Prof, your consistency too, you've been doing it. You've risen to the peak of it all, and you've helped in building institutions. Thank you very much, sir. For Madam here, my colleague, and my daughter, look, your future is good, though.
Yeah,
excellent. I hope you're coming to teaching. You're going to
That's the one I will ask her to do. She must be challenged to go and teach too.
And she has to be an academic.
Because that bagger there too is asking us how to recruit, and he ran away from teaching.
So thank you, Prof.
All right, thank you.
VC, thank you, sir.
Thank you. Aye. That closes it. We're going to give the speakers 1 minute to decide and answer or respond to anything they think. We must not respond to everything because some of them were only comments. So I will start with the youngest, please.
With respect to the statement or the question that was addressed to me about how lawyers now have to keep abreast with developments in the law, what I was trying to say is that it's not for people who are already in practice. Fine, if you're already in practice, you have a responsibility. You cannot begin to blame the law school from 10 years ago for not teaching you about maybe fintech now. They might not have had the foresight, or they don't have time machines to go into the future and discover new trends and return to teach it. But I was referring to within the system now, like one of the speakers commented, that there are new emerging trends that should be incorporated in the syllabus now, so people can learn them now. But as lawyers, we have a responsibility to develop ourselves, to read, to take courses, not just to stop and say, oh, we went to law school and it is sufficient. As I said at the beginning, law school and the universities will not teach us everything we need for legal practice. We also have our own responsibility. Thank you.
Yes, Prof. Somebody talked about an abuelo. I know what that means. And I was like, and if I come across a student that is an abuelo, I'll reform him. Because I have to reform him. Because when I come to this class, I always like to have a one-on-one interaction with them. When I look at you, I know if you are serious, you know. So at times I tell them, are you sure you're not overdressed? Which time do you have to dress like this to come to my class? When my class is 8. That time you should have used it to study and prepare for presentation. So that has to do with people that say you don't teach professional ethics, that it's moral. If you don't teach it, that people, when they come in, they have formed their opinion. Some have formed, some haven't. When they come, they form. We'll help them to form. At their youngest age, year 1 legal method. That was where I started at the university. You see these babies, when they come, ma this, ma that. You see a child that is, that is going through a lot of problems. You ask him, what is it? Ma, this is this. Ma, this is this, this is this. You now tell them, you have to do it this way. Remember your parents are spending so much bringing you here. You have to make them proud. But you have to make them proud. Are these things not counseling? We should do that as teachers. So bring an agboro to me. I will reform an agboro in my own way.
Thank you very much. Whistleblowing and abuse simply allow for fair hearing and due process to operate. It will take care of abuse because everybody will have their day in court. That is within the disciplinary process of the system. Why are we struggling to have our best to teach? Funding is one, frustrations of the system, and the system itself detests merit. Removing mediocrity from our DNA, it stems from, if you cannot beat them, join them. You stand aside, don't join them. You can see an example of not joining them. This is an example of not joining them. Let me tell you something. It has serious cost implications. Professor Ojukwu knows what he suffered. I know what I'm going through now because of what I did in LASU. But at the end of the day, you will have peace of mind. You will be happy wherever you go because people will know you as a man of integrity. Moving beyond regulatory obstacles, all of us must be engaged by writing articles to complain about such things, get the involvement of the NBA, engage also with our parliamentarians. Be close to them. You cannot run away from them. Be close to them. Whisper these things to them. At the end of the day, it may be tough, but we will get there. NUC BMAS, even the VC will confirm to you, NUC has done a lot of work, and ethics is now a critical component of the new BMAS that is on ground, including clinicals and the rest of them. I was a part of the team that did the review, so I can assure you that that is a major part of it. Lecturers who say you will not go to law school, that is part of what President Ojukwu was saying. You find out that some of us are simply not right to be in these systems. But at the end of the day, because of what has just been stated, you see that there was a time when both the good, the bad, and the ugly ended up in the system. And at the end of the day, it is for all of us to continue to complain before they are out. Admission process. The issue of admission process that you stated, very correct, but what did I do in my own time? When I got there, I found out that merit was 30%, discretion was 70%. What did I do? Scientific data. I showed them when we started out, this was how we were performing. This is how we are performing now. And I told them, if you allow me the opportunity of this pilot project for 4 years, you will see the difference. And it will be to your credit as assemblyman. It will be to your credit as Mr. Governor. They allowed it. and they left me. And that was why from 25, when you have first class, second class upper of maybe 25, the entire university moved to 75. Because they bought into that vision. You need to be engaging with them and let them know. Some of them, I agree, that power of political power will be in them. They will not listen to you. But some will reason with you, and you will be able to achieve effective output. Because as you rightly said, it is your input that will determine your output. I rest my case. Thank you so much for the opportunity.
Thank you very much. You.
Thank you. I think they have answered all the questions, including my friend here. Thank you very much. A lady asked, how do I sieve out false information? Simple. He answered it through investigation. Just last 3-4 weeks, I was in a workshop in Abuja, and the messages entered accusing HOD nursing of a lot of things. If you don't remove her, our nursing department will die. I there and then set up a committee headed by the provost of medicine, a very honest and good man, headed by HOD, health science, and that member, Dean, health science, is a woman, a very good woman, 2 other persons. I told them before I come back on Friday, I want a report on this situation. And by the time I came back on Friday, they were in my office waiting with a written report of more than 10 pages, which we sat down and discussed. And I presented it to management. So it's investigation to know whether what we are receiving here is correct or is false. On the issue of my student here who asked about in UK, masters, you pick a lecturer, you do this, you do that. You see, when we are talking about corruption, it's not only with lecturers. Many of our students are more corrupt than the lecturers. They offer this money. If you try that in Nigeria, strict lecturers, like my master, like my colleague there, like this man there, no person will choose their course. When I was doing my comparative criminal law as a master student under Ernest Ojukwu, there were only 4 of us that did his course. 4. 30-something did one other man's course. I won't mention his name. 30-something. Only 4. Meanwhile, we started 35 students from his course. He gave us assignment, 35 seminar papers. Midway in the 35 seminar papers, the others ran away. Only 4 of us ended up writing the 35 seminar papers for 1 semester. So, if you try it here, the serious lecturers will never get somebody to supervise. The students will go to the man that will pay. Once they pay the man will take one ancient paper somebody presented, remove the cover, add 1 or 2 things in between, and they present it for you. And you go through, and you pay the lecturer 200, 300, 1 million sometimes, especially from political office holders. In the terms of employment, the time some of us were employed is 100%. Even if you have a PhD or master's, if you didn't make some class upper division minimum, the university will never employ you to teach. It's arguable that if you pass through the 4 walls of a university with a very low 2-2 or with a third class or pass, you lack the critical thinking expected of a lecturer. But now it's no longer so, because the political class had infiltrated into the employment process. At the end, it becomes who? I'll give you an instance when I was Dean of Law, and that is why I agree with him that Deans of Law must stand up to this responsibility. When I was Dean of Law, the then Vice Chancellor, somebody applied for employment into law, packed up all the degrees and everything, and the Vice Chancellor, that particular Vice Chancellor, sent it to me for comment as the Dean of Law. And I said that this person is not employable. I gave all the reasons. I sent it to the VC. VC told him we will not employ you. In less than 2-3 months, the principal secretary to the then governor now wrote to the VC that this person is my candidate. And he met VC somewhere and said that I sent my candidates for employment. He refused to employ him. And the VC said, I can't remember the case. You can tell the person to bring the employment again. Then the person brought fresh employment. With only putting in the former employment letter, then with a covering letter. The principal secretary to the governor, the VC, sir, the principal secretary to the governor told me he met you somewhere and you said I should represent the work. I hereby represent my employment letter. The VC, the vice chancellor channeled it to me as the dean of law. And I just wrote, sir, if you go through your records, you see my former comment, nothing has changed. I returned it, and the VC didn't employ that person. I learned that that was one of the things that put that vice chancellor in trouble. This situation, this case now, was one of the things that landed that vice chancellor in trouble with that particular government as far back as 2005. So we have to, when we are talking about all this ethics, it is good we teach it. But somebody pointed out there, we must make decision to live up to the ethics of the legal profession. Thank you very much.
Can you give all of them a round of applause, please? Thank you. I will just summarize in 1 minute. Thank you very much. That has been a lively session. How many, just for recognition, how many officers of the MBA are here, either present or elect? How many officers? So we can recognize. You won't do me, Shakara. You know, you're only officer there. Nobody. How many deans are here? Let's recognize that, other than former deans. Only I can know that any dean, no, any lecturer, any dean. Where is the dean? Oh, come now, I will recognize you now. Aye. Because now you would talk about now since. Just giving the mic to say hello to everybody, please. Aye. Where is or give him mic. Is there any mic there? Just give him mic to say hello to us. Okay. Just introduce yourself, that's it. Yes.
Thank you very much.
Yeah.
Dr. Onyekachi Eni, Dean, Faculty of Law, Alex Ekwueme Federal University.
All right.
At Ikwo.
Thank you very much.
It's a very enriching process.
Thank you.
I say no more. Thank you very much for the education.
Thank you very much. How many lecturers are here? How many lecturers? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Okosha, I've recognized you. Bring that. There are 14, about 14. Now, you see where our problem is from. There are over 60 law faculties in Nigeria. Only one dean is here. There are at least 1,000 law lecturers now. Only 14 or 15 are here. There is no single elected, newly elected, or present executive member of the MBA in this session. Not a single one. So who are we talking to? Whom are we talking to? Any NUC man here? Then lie. Council? Now lie. Okay, council, yes. But you are double trouble here. You are not representing council now anymore. Okay, now you see where the problem is. Let me give you an idea why our conversation will be only a conversation and the hope may not be realized soon. Now, we have had summits and summits on legal education for the past 40 years. My colleagues can testify to that. And in fact, if we have had at least 12 summits, 12 different summits, different from sessions of conferences, I must have participated in at least 85% of them. Now, MBA had one recently in March, April at Afebeolela for a couple of days, the Summit on Legal Education. A communique was produced. And one stage of it that I expect from that communique, after many years of toddling, is that between that time and now, the Legal Education Committee, is there any Legal Education Committee member of the MBA here? Legal Education Committee. Legal Education Committee. You see, impossible. Legal Education, okay, no, only our coordinator. Now, I expect the Legal Education Committee to have drafted a statement of policy on legal education from that summit. and that what we will be discussing here only will be a review of that statement. For us to publish it and use it to force the hands of the NUC Council and other stakeholders to follow the bar's ideas on how to implement a reformed legal education. Every place in the world, professional associations decide how the profession is trained. And in Nigeria, all other professions decide how their profession is trained. Accountants, surveyors, medical people, all of them, very serious. The only professional association in Nigeria that does not care, except in talk shops like this, about how we are trained is Nigerian Bar Association. There's no single statement on the website or anywhere in the world, even under our beds, where MBA has made a statement on the type of thing they need for the bar, for members of the bar to be trained at LLB and at the law school. So we're talking to ourselves. And unless we have that, and many years ago, 2006, 2007, I made a proposal because I was legal education committee chairman of the bar. We wrote a policy statement and insisted that a directorate of legal education must be employed at the MBA. Not a toddler, not somebody who is learning. A serious person, policymaker, who will sit down there and interface with all the stakeholders on legal education and insist that the law faculties train how we want them to train. And help the law faculties also interface with their employers, that is the governments that employ them and pay them. Because they need somebody to be that intermediary, to force the hands of the state to look after them so that they can also do the work well. There's no such thing. Now, my boy Larry has mentioned that there was a draft of the minimum statement for NUC many years ago. Since 2012, we have been reviewing it. It was one of those states that he introduced ethics in the curriculum. But can I tell you, sir, there is a draft now that is 1 week old. They have removed ethics. Ethics has been removed from that draft. The only thing that has been introduced in the new draft is a special course on common law and Sharia law. Now, there's a committee, a team of our colleagues who have done that review. And in the courses, like a few courses, the only new things that have been introduced is customary law and Sharia law. Customary law and Sharia law. Those are the new things introduced. There are statements, benchmark statements that are so fine at the beginning of the statement, but they are not reflected in the courses. There are minimum courses produced there that are compulsory, and they constitute 86% of the courses. And only less than 14% have been allowed the faculties to maneuver and introduce their courses. So where is the hope going to come from? The team that reviewed this curriculum were picked from Bayero University, Ajayi Crowther University, one person from Council of Education, one person from Bayero University, and 2 toddlers employed in the AUC were the committee that reviewed the curriculum of LLB for implementation post-2020. There's no MBA, man. There's no MBA. There's no serious, apart from the chairman who has a lot of experience in this area, there are too many other people who are engaged in this aspect of transformation who are not involved. What about the cross-cutting border thing? Where are the employers in this committee? Where are the employers? No employer was engaged in this committee to review the curriculum. Where are the students? No student was engaged. Where are the new students, new lawyers, like Victoria, who would be there to say, look, see how our experience is? There's no seriousness in the country, unfortunately. But as Lanre said, and my colleagues have also supported, as long as we are still here, we'll continue to fight until we have a light in that tunnel. Thank you all for coming. So I think for you, your seriousness and insistence in remaining here, even with the time passed, yes, Ben will give us the last talk because he is the boss here. I would like us here to give you 2 bozas. Guys, let's give them 2 bozas. Boza. Only two.
Thank you. Thank you very much, my prof. My prof, we are very grateful to have you moderate this session, and we are very grateful to all the panelists. Distinguished ladies and gentlemen, I believe our speakers do deserve another round of applause. Please, let's give it to them. They deserve it. You will agree with me that this session has been very enriching, and our speakers have made very useful contributions to the improvement of the legal education system in Nigeria. And we hope that their recommendations will be duly implemented. Thank you very much. In appreciation of their useful contribution and how extensively they have discussed these issues, I'll be inviting Professor Abdul Karim Abubakar Kana, the Attorney General and Commissioner for Justice of Nasarawa State, to help present gift to the speakers. Prof, please, from there.
Well, I am asked to make a presentation. It's the custom that for them to have sacrificed their time and, of course, lots of resources and energy to come and do this, and you can see how much they have done. I mean, we can feel it, we can see it, we can even smell it. It's what they've been doing. I mean, Prof and Professor Juku, every MBA conference, legal education meeting, you see them there, you must. You know, so for them, it's a continuation of a lifetime program and project they've set up for themselves. And our only prayer and hope is that may they succeed. And also, some of us who are coming behind them, we should also imbibe and emulate and learn, so we can carry on with what they're doing and also hand over the baton to those who are coming after us. Please say amen. Thank you very much. On behalf of the President of Nigerian Bar Association and the Chairman of the TCCP, that's the Planning Committee, I will present to you this very little talking. The MBA in the last 2 years have developed this. I remember when I made a presentation at the Legal Education Summit in Ado-Ekiti, I was also given one, and I still have it on my table. I think it's a good tradition they've developed, that for each time you come, make such a presentation, you are given some token, something you can keep on your table and continue to remember. So thank you very much for what you have done and your contributions to the bar, contributions to humanity and generations yet unborn. Thank you very much, sir. Thank you, Prof. So, well, to our Amazon, I think you gave us lots of hope today. Your presentation really gingered us. And it only goes to confirm that we may continue to complain about many things not going right in the country. But in reality, we're not doing badly, and this is an evidence that there's still something good coming out from something in this country. It is only in Nigeria that a person will park a 50 million naira Range Rover outside and come in to make a presentation and be complaining about poverty. We will complain too much. I think it's time we will complain less and do more. Thank you very much. Thank you. Oh, okay. For my colleague, she always speaks very brilliantly. I am glad that she has remained patiently within the academics. I spent 6 years for my PhD. At some point, I ran away. And because I'm a very obedient student, my supervisor followed me to my house and said, look, Kana, we will not be there forever to continue to wait for you so we can supervise you. Come back and continue. I said, ma, I can't. And that was Professor Jamila Nasir. You know, and she has to follow me and Professor Joshua Muputon, two of them. They had to come and say, look, come back and finish your PhD. I said, okay, sir, I'll come tomorrow. So congratulations. Thank you for your presentation. Yeah. Prof, you know, my first experience with Prof was in New York Athletic Club, I think, during an IBA presentation. And I was listening to his program very carefully. And I have this ringtone in my phone. It's a call for Muslim prayer. And halfway through his presentation, it drank loud, and all those white people with their white faces turned to look at me. But he wasn't surprised. So what did he say? That's an interesting ringtone. Prof, thank you very much. I'm most grateful, sir. Thank you, sir. Thank you, sir. Well, most certainly, the first and the first. I will not say the last but not the least. I will not use that one. Prof, thank you very much. I mean, you know what's in our hearts, all of us here. Thank you, Prof. I'm most grateful, sir. Thank you. Yes, sir. Thank you, Prof. Thank you, sir.
There will be a group photo